coming in, but those images will come in shortly form. But let's just touch on this basis.
Before I get to that, I think I need to pick up from where my colleague has left on the decision by Senator Sifuna not to second the motion of the committee, of 11-member committee. I think he wanted, or the Senate generally wanted to have...
So unfortunately, the big day is here and the time has come, and I can see then the courts are commencing this particular hearing, if I may call it that, Wakili. Is it? Is a ruling. A ruling, okay, indeed. So I want us to cross over, as we should honorably do. It's happening right now, and listen in, and we might come back with the panel anytime from now. Let's cross over to Milimani Law Courts for the 3-judge bench verdict on the matter.
Good morning, my Lord.
Good morning.
My name is Plea. I hold brief for quorum with the Senior Counsel. Together the team representing the first petitioner, that is Tom Masharia, Andrew Buge, Sakimpa, Faith Waitwa, and Victor Swine for the first petitioner.
Yes.
We do not see how the second to 6. Your Lordship, my name is Gachagua for the second petition. Together with my learned friend, Mr. Ombuko Njohi. And in addition to that, I am holding a brief for Mr. Debo Njiro for the second to the 6th petitions. If it pleases the court.
For the
Second to 6th. If it pleases the court, in the matter, my name is Simon Mburu. I continue on record for the 8th petition.
Hamjambo. Kwa niaba ya mzungumzaji namba 9, kwa jina naitwa Nepal na watana na
With the permission, judges, there is a concern about members who are online. They said that they need to be unmuted so that they can participate in it.
Who appears for petitioner 10? Caroline Wombui.
For purposes of counsel who are online, are you able to hear us? If you are online and you are part of these proceedings, can you please say good morning?
Good morning, my Lord.
Thank you. Petitioner 10, petition number 10. Then we'll go to the respondents.
My Lord, my lady, if it pleases the matter, my name is Midimo Benson. I do appear for the first respondent. Lord, I have the privilege of introducing my other colleagues. For the second respondent, my Lord, I, Midimo, hold praise for Mr. Nyamodi and Mr. Gumbo. For the third respondent, my Lord, my learned colleague, Miss Opola, present before you, holds brief for Miss Kanji for the third, fourth, and seventh respondents. And my Lord, my learned colleague, Ms. Akama, who is present before you, holds brief for Mr. Uyoni for the fifth respondent. And my Lord, I, Milimo, hold brief for Mr. Wanyama for the sixth respondent. And my Lord, for the eighth respondent, my learned colleague, Mr. Akama, who is present before you, have been requested to hold brief for Mr. Vita, who appears for the eighth respondent.
For Mr. who?
Mr. Vita. For the eighth respondent of the and that be for the
Yes. Interested parties?
May I give you my notes, of the bank, my notes and my name, and it was not too happy. I feel for the party, so that we can be issued, one of them, Maura Abad.
For which? Yes. So we are done. I think we are done with the quorum, unless somebody's name has not been recorded. I believe that you are ready to take the ruling pursuant to the applications which we had yesterday. This is the ruling in the consolidated applications, in the consolidated petitions. We have considered the submissions of the parties, the facts in those applications, and the arguments and submissions of parties, and we have prepared a ruling which will be perfected in the course of the day, but whose summary is as follows. We have given the facts of the proceedings, the relevant submissions and arguments, and for the purposes of today and this morning, because we don't have much time, we'll give you the abridged version of our ruling. Analysis: having carefully considered the applications, the responses, the party submissions, and the various decisions referred to, the court distills the following issues for determination. 1, whether the applications are res judicata. 2, depending on one above, whether the applications are merited. As to whether the applications are judicata, the nature and applicability of the doctrine of res judicata is a well-trodden path by the Kenyan courts. In petition numbers 42 and 43 of 2014, which were consolidated, that is Kenya Commercial Bank Limited versus Muri Coffee Estate Limited and another, the Supreme Court of Kenya, in an elaborate fashion, illustrated the operation of the doctrine of res judicata. We are not going to go into the details about the doctrine of res judicata, but we have considered it there. We have cited several cases in support of the arguments put forth by parties. And returning to the matter at hand, there is no contestation that the first petitioner herein regarding Gachagua filed and prosecuted an application seeking conservative orders in Nairobi High Court, constitutional petition number E 550 of 2024. On 15th of October 2024, His Lordship Judge Muita delivered a ruling on that application. For reasons contained in that ruling, the application was dismissed. The nature of the conservative orders which were sought in the said Nairobi High Court constitutional petition number E 550 of 2024 related to various facets of the impeachment proceedings against the first petitioner in this case before the National Assembly and the Senate. Likewise, the applications subject of this ruling also challenge the very pending impeachment proceedings. Learned Senior Counsel, Mr. Paul Mute, urged this court to nevertheless deal with the instant applications for the main reason that this court, as constituted, is an expanded multi-judge bench of the High Court as opposed to the ordinary single bench. The respondents did not, however, find favor with the above position. It was vehemently contended that the instant applications ran afoul the settled doctrine of res judicata. This court has diligently addressed itself to the above arguments. Unfortunately, we did not come across any holding persuasion that a decision of an expanded multi-judge bench of the High Court of Kenya is superior to that of a single judge. This court therefore finds that the challenges raised in the instant applications are similar to those dealt with in Nairobi High Court constitutional petition number E 550 of 2024. In applying the tenets of the doctrine of res judicata to this matter, we have no doubt and do hereby find and hold that the applications herein are in four corners with the one dealt with in Nairobi High Court constitutional petition number E 550 of 2024. The applications are hence caught up by the doctrine of res judicata. For clarity, the issues raised in the applications before us were fully canvassed by a court of competent and concurrent jurisdiction. Having found as such, and for abundance of caution and the completeness of the record, this court will still consider the second issue, and that is whether conservative orders ought to issue. As a well-settled principle in law, a court dealing with an interlocutory application seeking conservative orders is called upon to exercise a restraint and to resist the temptation of making final findings at such stage. We have cited cases or authorities emanating from the Supreme Court on that matter. Therefore, a court exercising jurisdiction in an application for conservative orders must sustain that delicate balance by ensuring that it does not delve into and determine issues which largely fall within the realm of the main dispute. The nature of conservative orders was discussed in the Supreme Court of Kenya Civil Application number 5 of 2014, Gachagua Peter Munya versus Dixon Mwenda Githinji. And I've stated what the court said. It was also discussed in other cases which we have referred to in this. On the principles to be considered by courts in dealing with applications seeking conservative orders, the locus classical case of Gachagua Peter Munya, which I've said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also cited the case, the court in Wilson, Kaberia, Nkunja. You'll find them in our ruling. Having considered those, then what we then looked at are the elements for granting a conservative order. We are giving them to you in point form, but we have discussed them in detail in our ruling, which we shall give. For the sake of completeness of the record, we have dealt with the merit of the application and whether conservative orders should issue, whether prima facie case has been established. We take the view that the same has been established. The applications raise constitutional issues that require further judicial interrogation. Whether any prejudice will be suffered by the applicants. No prejudice if the applications are not granted at this stage. The process is a lawful constitutional process, and the Senate will conduct a trial where all the issues being raised before the court will be raised and determined. At the moment, we are being called upon to anticipate the outcome of a process yet to be completed. The application at this stage is premature and anticipatory. Should the petitioner not succeed, the petitioner still have an opportunity to approach the court after the process. The applications are not without a remedy. On the issue that has been raised that as soon as the Senate impeaches the DP, if at all that happens, that the DP immediately ceases holding office and he cannot reclaim office, we take the view that every office holder can only assume office legally and constitutionally. The assumption of office cannot oust the court's jurisdiction. The court has unfettered jurisdiction to check on the constitutionality of the process at whatever stage. Whether the grant or denial of the conservative order will enhance the constitutional values and objectives in the Bill of Rights. We find that exercising restraint at this stage will enhance and allow independent institutions of government to function unhindered and in their fullness, except in the clearest of cases. It is our view that this is not one such case where intervention is automatic. The issues raised by the parties will require to be interrogated. We therefore find that the enhancement of the constitutional principle of separation of powers will be best served by declining the application at this point. Whether the petition will be rendered nugatory, we find and hold that it will not. The petitions challenging the process of impeachment, the petitions are challenging the process of impeachment. The substratum of the petitions will not be lost. The court is still able to grant a remedy even after the process is conducted, even after the process is concluded, and as such, the court will not be acting in vain. On public interest, we find that the public interest tilts in favor of allowing the constitutional process to proceed unhindered. This position, therefore, deriving from the foregoing, the following final orders do issue. The consolidated applications are hereby disallowed, caused to abide the outcome of the main petitions. That is the ruling of the court.
As we wait about the ruling, on behalf of my colleagues, I know senior counsel major would have wished to do because I am proud about done. Your lordships for the same time taking a lot, knowing that we left here yesterday at around 9. Lord, I have no doubt that you might not have